following day, he went back to his office. When Peter came to listen to Peter the sixth, he was not waiting on the video the court had marked to 10, but also invested on the history of the same in terms of the recording of all the conversations and the speech. At the same time, he confirmed having also been introduced to Peter before. He was only waiting for the same to understand how to tell the same and what advice he was taken. Thereafter, when the company released the results, they headed straight to the accused office to the headquarters and Peter headquarters. They maintained that it was the accused person who started in the office from the reception except he was still outside. Inside, the accused was only welcome him but also ensured from him how much he had. Then he replied that he had $200,000. He then demanded that the same from him. When he complied and handed over his 1 minute.
Was moved to Ooko by PW2, who further confirmed that during their foresaid appointment meeting with the accused held on 1st December 2020, he never had the accused person demanding above evidence. It is quite discernible therefore that if indeed the accused person ever requested for a sum of $500,000 as a financial advantage or bribe from PW3, then such a request was not made. First, the date when this offense is alleged to have been committed by the accused, rendering the same defective. The Court of Appeal, in the case of Peter Ngure Mwangi's Republic 2014 EKLR, stated that, and I quote, a charge can also be defective if it is in variance with the evidence adduced in its support. Quoting with approval from Archibald Criminal Pleadings, Evidence and Practice, 4th edition, page 52 to 53, this court stated in Yongo versus Republic that in England, it has been said an indictment is defective not only when it is bad on the face of it, but also when it does not accord with the evidence before the committing magistrates, either because of inaccuracies or deficiencies in the indictment, or because the indictment charges of offense not disclosed in that evidence, or fails to charge an offense which is disclosed therein. And two, when for such reason it does not accord with the evidence given on trial. End of quote. Be that as it may, PW3 went further and stated that later on 3rd December 2020, after being referred back to the accused by Mr. Hamid, he called the accused, but he declined to receive his calls. Thereafter, the accused sent him a text message in which he advised him to download a Signal Call private messenger application from a cyber cafe, which he did, and informed him as much through a text message. He maintained that the accused responded to this text message to it, and I quote, good, I will call you there, end of quote. Later that night, the accused called him through the said application and informed him that another filling station in Migori had equally been found with adulterated fuel like theirs, and hence the same had complicated reopening of Nyanginja filling station. Consequently, he demanded to be paid $500,000 before he could authorize the reopening of the same. It was further his evidence that he negotiated the said figure downwards to $200,000. He also confirmed that the said application was not keeping any text messages exchanged, as the same would just get deleted immediately thereafter. Again, if I may pause at this point, this was the first time that PW3 alluded to the aforesaid sum of money being demanded from him by the accused, and even how they negotiated the same downwards. And this happened on 3rd December 2020 at night, and not 2nd December 2012 as put in the charge sheet. He went further and stated as follows, and I quote, after realizing that the said application was not keeping the text messages, I decided to take some screenshots of our text messages conversations with the accused person, end of quote. Ordinarily, therefore, the first evidence which could have corroborated PW3's above contention of the accused person requesting the said sum of Kenyan shillings $500,000 which he bargained downwards to 200,000, whether on 2nd December or 3rd of December, is the aforesaid screenshots which he alluded to as having personally taken from his own cell phone. However, none was tendered in evidence, despite having not alluded in his evidence if the same equally got deleted, which I do not think so, since the same must have been saved on a different platform altogether other than the said application which he downloaded. Even PW7, who testified as a forensic digital expert and confirmed having examined his aforesaid Samsung cell phone, never alluded to the existence of such screenshots. The furthest this matter went in this regard relates to PW7's evidence tendered in respect to the mobile digital data which he extracted from PW3's Samsung cell phone based on two cell phone numbers, that is 0722 799 109 and 0728 080 664, and compiled his findings thereon in a report marked Exhibit number 26. As per his said findings, he contended that there were a total of 16 call logs communications to the number 0722 799 109, with the first one being on 9th December 2020 and the last one being on 10th December 2020. He also maintained that there were text messages communication with number 0722 799 109, totaling to 13 as from 2nd December 2020 to 10th December 2020. Further, he confirmed having not found any call log communication to number 0728 080 664, save for the one text message dated 9th August 2020. In terms of the data on the signal team, but which nevertheless was not tendered in evidence. Flowing from PW7's above evidence, the inevitable question that begs for an answer is whether or not, first, no liaison officer from Safaricom Company Limited as a mobile phone service provider was ever called as a witness, albeit to corroborate PW and 0728 080 664, the aforesaid highlighted call logs, text messages exchanged, and if the aforesaid sexual private messenger application was indeed used in their said platform, despite being the sole custodian of such crucial information.
Evidence, that is, digital data which he extracted from the said Samsung cell phone, the same ought to have been accompanied by a mandatory certificate in terms of Section 106B4 of the Evidence Act, not 6 subsequent 4 of the Evidence Act. This certificate ought to have been executed by PW7 in relation to the Samsung. The certificate must identify the electronic record containing the statement, describe the manner in which it was produced, and also give such particulars of any for the purpose of showing that the electronic record was produced by a computer. In the case of honest certificate, is also to ensure the integrity of the source and authenticity of the data, so that the court may be able to place reliance on it. This is important because electronic data ought not to give relevance to the evidence. End of quote. Further, dealing the same issue, Oimeke, in Godwin Solidarity was reported in 2019, party wishes to rely on electronic evidence under the foregoing provisions. The one who undertook the actual work of processing that electronic evidence must prepare a certificate whose contents are provided for in Section 106B4 as follows. A, the best of knowledge of the person stating it. The need to strictly comply with the law when dealing with electronic evidence in this era of technological advancements cannot be overemphasized. We must strictly pass the test A in law. End of quote. Guided by these decisions, I do find and hold that the entire evidence
to prove to the required standard the first count, as preferred against the accused, but at the same time, I find that the second count was properly proved. So in the first count, I acquit the accused under Section 215 of the CPC for lack of sufficient evidence, but for the second count, I find him guilty as charged and proceed to convict him accordingly in terms of the aforesaid provisions of the law.
urge the court to consider the following. One is the position the accused occupied at the time of commission of the offense. Second,
Yes, follow. Yes.
secondly, the victim of the offense.
The?
Victim of the offense and the fact of the crime. And thirdly, the nature of the crime. Your Honor, at the time of the offense, the offense accused was in a position of power and authority. As the Director General of Aircraft. A position of trust which mandate affected.
A position of trust?
A position of trust
Yes.
which affected most sectors of the economy. So, and besides the general citizens,
Yes.
besides the general citizenry, the other victims of the crime were PW1 and PW3. Who operated and engaged at petrol station.
See?
And who depended on the said filling station equal to living. This crime perpetrated by a person in a position of authority resulted in the undue delay in the reopening of the fuel station. denied PW1, PW3, as well as employees of the filling station their much needed income and further denied the government
You see, the much needed what?
income
Yes.
and further denied the government collectible tax for the period was closed. And thereby denying services offered by the government to the people. Your Honor, the corrupt behavior of the accused erodes the trust in public institutions which are mandated to act in the best interest of the people and the same behavior acts as a roadblock to economic development and ends up propagating inequality and injustice. We therefore petition this court to be unequivocal in its sentencing that issuing a sentence that will serve as a deterrent and restore public trust in institutions meant to serve the people.
time has taken a turn for the worst as a result of the sin. He is now conscious of his actions and pleads with the court that he be given a lighter sentence. Your Honor, the actions of the accused, which he regrets, and the circumstances under which they arose, the evidence the court has noted was that the complainants involved in the process of evading revenue by selling products which were adulterated. Therefore, while his later actions were not in line with the law, his earlier actions were in tandem in assisting the government to collect revenue. The accused is a family man and is currently the only breadwinner for his family.
The prosecution submissions as well as the accused mitigation were filed on his behalf by his counsel. I've also taken into account the amount involved in this matter as far as the count which was proved. That is Kenya shillings 200,000, which was an operation money from EACC. However, I also take into account that no money was lost as a result of the accused actions. However, I do concur with the prosecution submissions that at the time of this incident, the accused held a senior position, that is as DG or Director General, essentially the CEO of IPA, a position which not only called for high responsibility, but also for utmost integrity, not only on behalf of the other employees therein, but also on behalf of the people of Kenya as a whole, and which two elements, unfortunately, the accused failed to exhibit as exemplified in this matter. I do hereby sentencing, that is for count 2, to a fine of Kenya shillings 1 million, in default to serve 3 years imprisonment. The proceedings and the judgment shall be typed. I know these are matters which normally appeals. The proceedings and the judgment shall be typed.
Thank you. The pandemic goes, I believe that
See, we're not guilty of requesting, but